Welcome, CJ 379 students. My name is Ernesto Chavez, and I'll be your instructor for this course, which is both a criminal justice and a political science course. Our assignment for this past week, January 7th through the 12th, has been chapters 1, 2, and 4 in the text that you're aware of, America's Courts. Make sure you have the proper edition, the 10th edition. And I just want to give you a little primer about how to interpret the information, the data, the cases that are in the textbook, and how to proceed with the class, as I've made a few adjustments. For one, the focus in the course is going to be on 3 issues. First, it's going to be on the controversy and the disputes that form the basis for the criminal justice system. As you know, there are parties such as judges, police, prosecutors, bailiffs, other court personnel, and defense attorneys. And one of the central themes of the course is that these parties are frequently in heated disputes and controversies, and the cases themselves make up very controversial matters. So we'll want to focus on that as how these matters get resolved. And one of the ways that the justice system does this is by focusing these controversies on key issues, such as the suppression of evidence, the mental state of the defendant, the conduct of the prosecutor, and the role of the judge in resolving the disputes, among other various methods of resolving these controversies. So, number one issue is to look at the cases and the situations in the text in terms of how these parties are frequently in heated conflict. Secondly, the criminal justice system is much like a sporting system of justice. And by sporting system, I mean the parties are there, especially the prosecutor and the defendant, to engage in a kind of tightly fought game in which certain procedures hold sway and must be followed, but at the same time are maneuvered, and the parties as well stake out their positions in cases in order to gain the advantage one over the other. And if one makes the mistake, the other one takes advantage of that. This I refer to as the sporting system of criminal justice. That's not in your text, but you ought to think about the materials in terms of, for example, a trial or a suppression hearing or an arraignment as gamesmanship, where 2 parties line up their chess pieces in a certain array as to position their forces against the other party. So one key example of this is an effective prosecutor is always thinking about what the defense's next move is going to be, and conversely, an effective defense attorney is always thinking about the way the prosecutor thinks of the case so that they can be prepared for every move in this sporting system of criminal justice. Finally, you ought to think about the text materials in terms of the history of the criminal justice system arising out of common law and how these matters all came about from a common application of the law across separate sectors of the country. This originally happened in Norman England, as the text states, and this is all referred to as common law. So cases don't get resolved unless the matters come before a court in a controversial setting. They don't have application just to one party, but they have application broadly. So precedents must be followed in order for that to make any sense and have any order. And those precedents must be respected, and that's called stare decisis. Once a type of case is decided, other courts should follow that. All these different aspects of law are referred to as the common law. So pay attention to that aspect of the course when you analyze different stages that are pending. We've chosen our case up close, our CUC, as the Casey Anthony case. And I've asked you some questions about that case, and I would just like to give you a short primer on that case as well, and then we'll move on to the next lecture in a subsequent video. The Casey Anthony case raises a specter about whether the sporting system of criminal justice actually worked. And I think many of you say that it doesn't. I'd like to pose the counter-argument. I'm sorry, many of you said that it does, but I'd like to pose the counter-argument that the system did not work. And this has to do with our flow chart. We have a flow chart on Moodle describing the various stages of the criminal process, and one of which is approximately the time when the prosecutor decides to charge a case. That's a crucial space, or a crucial time and space in which the prosecutor has to make the proper decision, because they have to prove all their cases beyond a reasonable doubt. There is an option, instead of just charging a case right away, which you see much too often. A prosecutor can wait and gather further evidence, because a prosecutor is in a special position to wait out the unfolding of evidence. Sometimes that's not the most wise thing, but sometimes when the evidence is incomplete, as it was in the Casey Anthony case, a prosecutor still has the option to not charge and almost wait in hiding in the grass to see if a case will develop or a break will come in a case. And I'd like to pose the question about whether you think that was an option in the case, and if the prosecutor had waited, maybe some of this new evidence that is now coming out would have come out in time for a stronger case. And the question is, did the prosecutor jump the gun in that case? And I'd like you to just to give you that as food for thought. This ends this first video introducing Criminal Justice Class CJ 379. Thank you.